subject, you would want to stay in and listen to those views. And then we have more coming your way next. Actually, I'm going to do that interview now. Let me go to the phone lines and speak to a former Attorney General, the Honorable Ni Ayikoi Otoo. He has been the leader of the bar in the past, and he understands the workings of the judiciary, but of course he also knows the workings of the legislature, the executive, et al. Let me speak to him about this. Sir, you're welcome to Eyewitness News.
Thank you.
My question would be, when people say judiciary is independent, executive independent, legislature independent, at what point can the three interrelate in the manner that we have seen it today? So the judicial independence, the legislative independence, and the executive independence, at what point can we see one of them involving themselves in the works of another like we've seen today?
Well, the province of the judiciary is to interpret the law. So when it comes to interpretation of the law, there's no issue of independence as regard other organs, in which case anything which involves the interpretation of a constitution can go to the judiciary. So be it a legislative matter or an executive matter, cannot go before the judiciary. If anybody alleges that an act or of any person is inconsistent with the provisions of the Constitution, that person can always go and ask for an interpretation. So to that extent, you cannot talk about any executive immunity for acts of a president or any immunity for the legislature. Because you remember there was this issue which involved, I think, Justice Abdullahi, when he challenged certain acts of the legislature. And I told him that with 5-0, if he says he's going on a review, I don't see what will change. Eventually, they went for the review and got anything. But specifically to your answer, there's no independence when it comes to judicial interpretation, because that role is given to the judiciary. In the same way, the judiciary cannot, on its own, pass laws and sign them. A bill, you cannot send a bill to the judiciary and ask the judiciary to look at it and pass it into law. It can't do that. Again, the legislature itself can make a law, but that law will never come into force until the president has signed. So these are checks and balances here and there. It will not come into force until the president has signed it. If it doesn't sign, and we all know the LGBTQ matter, which is pending, is no law. It's been passed, all right, but the president has not given his assent. So these are some of the issues.
It's good you mentioned the LGBTQ thing, which is actually also before the Supreme Court. Many are saying the swiftness of the Supreme Court today, they find it surprising. In fact, Eduji says it is very strange. We also know the maxim that says the wheels of justice grind slowly, except that this one ground so fast, and people are wondering, why should this one be dealt with expeditiously when there are other cases in the past? You have visited the Supreme Court so many times as leader of the bar and also representing clients. What are the things that the Supreme Court considers in dealing with matters expeditiously or otherwise?
I think that argument is flawed. The argument is flawed in the sense that this is an ex parte application. An ex parte application is an application which is not served on other parties to the suit, and it is looked at from the agency situation. No, I'll take this opportunity to advise the NDC. I think they shot themselves in the foot by talking too much. When we talk of strategies and tactics, and I think it lost on them completely, and they were doing things which really frightened the majority and pushed them into trying to protect whatever. We're going to change the amend laws, we are going to do this, we're going to flip, we are going to just keep quiet and do your thing. At the end of the day, when you get whatever you want to get, fine. So I want to give this advice to both sides. If you have anything you want to do, think about your strategies and tactics, and stop just making too much noise. I mean, the noise was such that when you frighten somebody, the basic instinct of a man is to protect his life, is to survive. So all the things they did, to me, had compelled the majority to take the decision they have taken. And I'm saying the argument is flawed. You see, when you file a motion on notice, then both sides must be served, because the thing that the judiciary doesn't want at all is not giving a hearing before condemning anybody. So when you file an application on notice, then it will take some time, because you have to serve the other person, allow the other person to respond, and then you look for a date when the case can be heard and all that. But when you file an ex parte application, only one party is to be heard. The other side will not be heard. Now, it is only used in the extreme cases and in emergencies. And as I said, the NDC were just overreacting and doing things that push these people to take this extreme position of going to take an ex parte application. Now, when it is an ex parte application, because the other side has not been heard, it will stay for only 10 days. And then after 10 days, it becomes spent, and you have to put it on notice. So whatever arguments will be made about LGBTQ matters can only come in after the 10 days. But what happened today was an ex parte application where nobody was served, which has to do with extreme urgency and all that. You understand? So you cannot compare it with the LGBTQ matter. That one is not an ex parte application. As far as my memory serves me, I'm not aware that an ex parte application was filed and the Supreme Court refused to give a date. I'm not aware. They wanted the matter to be heard. Okay.
Now, the decision of the court is to stay the execution of the Speaker's action or decision yesterday. Now, the question would be, what the Speaker said yesterday, is this something that has to be executed to an extent that it has to be stayed immediately, so that in the interest of governance, like the MPP side argued in court, is it something that is so needing of a stay of execution?
Playing for your country, easy. Scoring, easy. Avoiding injuries, easy.
Something that is so needing of a stay of execution.
Again, that is a misconception from the reporter. I don't think they use the word stay of execution. If a judgment is incapable of being stayed, then what you do is to ask for a suspension of the execution processes, a suspension of implementing that thing. Like the minority has already given notice that on Tuesday they are going to reconstitute all committees, and then they will proceed to appoint a new deputy speaker, and then they will even proceed to file papers to amend the e-tax, a communication tax and all that. So they've told us their intentions once they take over on Tuesday. These are the matters that require something to be done about them. If you don't do anything about them, then it means that they are going to run route and do whatever they want within the period. And you know that within this time, nobody can hold a by-election. So the danger is that something has got to be done, or things will go haywire. Now, remember, for example, when you ask the MPP presidential candidate, Dr. Mahmoud Bawumia, to amend the e-levy, what you are saying in effect is that the laws, appropriation laws, the budget, everything that has been made based upon these levies must also have to go. And so it becomes difficult, for which reason it tells you that wait for me to take power, then I'll do the amendment. If I do the amendment now, it would affect the appropriation bill, the budgets and everything that we have done, because we are depending upon these taxes to fund certain, projects.